Juvenile Detention, Sexual Assault, New York, Civil Rights for Young Survivors. Attorney Andrew M. Stengel. Juvenile Detention Sexual Assault in New York. Lawsuits, deadlines, and survivors' rights. Young people in New York juvenile detention are among the most vulnerable individuals in the justice system. Sexual assault in these settings, whether by staff or by peers, violates the Constitution. Civil remedies exist, and limitations periods for minors give extra time to pursue them. A New York sexual assault lawyer who handles juvenile detention cases knows how to navigate the rules. Juvenile detention sexual assault lawsuits in New York cover survivors still under 18. They also cover adults looking back at abuse from their years in youth facilities. We handle both at the law firm of Andrew M. Stengel, PC. This post explains the heightened duty of care, the deadlines, and what families should know. Most importantly, it shows why moving fast matters. Why youth in New York? Detention get heightened constitutional protection. Youth in detention hold every protection available to adults in custody. On top of that, they receive extra protections tied to age and developmental vulnerability. Courts have long recognized that young people in detention need heightened supervision and care. PREA standards include specific provisions for facilities housing anyone under 18. For example, cross-gender supervision restrictions run stricter in juvenile settings. Staff training requirements emphasize the unique vulnerabilities of young people. As a result, juvenile facilities owe a higher duty of care. Both federal civil rights case law and New York state decisions reflect that recognition. Our guide to PREA, Rights After Sexual Assault in New York, explains those protections. The New York juvenile system and where these cases arise. New York's Office of Children and Family Services oversees juvenile detention. Secure detention centers, limited secure facilities, and non-secure placements all fall within OCFS oversight. Additionally, PREA standards apply across the entire system. Cases arise at the Crossroads Juvenile Center in Brooklyn, the Zerega Juvenile Center in the Bronx, and upstate secure facilities. Constitutional protections follow young people into every one of those placements. Furthermore, the State Commission of Correction monitors some juvenile facilities alongside adult corrections. That oversight matters when a survivor pursues civil accountability. Each layer of oversight creates documentation that can support a civil lawsuit later. Civil lawsuits and extended deadlines for minor survivors. For minors, the clock on a personal injury lawsuit pauses until the survivor turns 18. From that point, the standard limitations period begins to run. Consequently, adults who experienced abuse as juveniles may still have viable lawsuits. In addition, the Child Victims Act extended the limitations period for sexual abuse lawsuits involving minors. Meanwhile, the Adult Survivors Act covered a separate group of adult survivors through its own look-back window. Both statutes opened important pathways for survivors of juvenile detention sexual assault. Recent case law continues to expand recovery options for juvenile survivors in New York. Our overview of childhood sexual abuse lawsuits in New York walks through these deadlines. Therefore, the practical first step after release is a conversation with counsel. At the law firm of Andrew M. Stengel, PC, we analyze limitations periods carefully and identify every available window. The long-term impact and why damages are substantial. Trauma from sexual assault in youth detention shapes a survivor's path for decades. Educational achievement suffers. Trusting relationships do not come easily. Persistent mental health challenges compound the ordinary difficulties of reintegration. Civil litigation compensates these impacts fully. Damages account for the developmental years lost, the opportunities cut off, and the treatment ahead. Compensatory damages cover those losses, including emotional distress damages recognized under New York law. Beyond that, punitive damages may reach staff members or decision makers whose conduct was reckless or malicious. Juries take a survivor's developmental stage seriously and award damages that reflect a lifetime of harm. What parents and guardians need to know. Lawsuits can move forward on a child's behalf while the survivor is still a minor. A parent or legal guardian can act as next friend when a minor cannot sue independently. Once the survivor turns 18, they can pursue lawsuits in their own name. Families of minors still in custody can preserve evidence and start an investigation early. In fact, early action often makes the difference between strong and weak documentation later. We advise families on timing and approach. Victim advocacy services and counseling referrals remain available while a case is pending. Justice for young survivors starts with the law firm of Andrew M. Stengel. Trauma from juvenile detention. Sexual assault does not have to define a young person's life. However, civil lawsuits deliver real accountability and damages. At the law firm of Andrew M. Stengel, PC, we represent juvenile survivors and their parents. Adults who suffered abuse in youth facilities years ago will find the same commitment. The team coordinates with adolescent trauma specialists and juvenile justice experts. Every consultation gives families a clear sense of what is possible. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.